Welcome to this brief video on how to answer problem questions in law, or more specifically, how to answer problem questions in law by applying or through the ILAC method. Now, before moving on to discussing what the meaning of ILAC method or discussing what the ILAC method is, we need to first look actually or understand what is the actual purpose of a legal education. Why do students come to study the law and study the law? And why do they study the law for 4 years or more? Now, the purposes of a legal education could be said to be twofold. One, to gain a deeper understanding of the law, and second, to acquire the ability to, quote, think like a lawyer. So fundamentally, a good lawyer or a good legal mind knows more law than others, by which I mean a lay person or lay people who do not have specific knowledge of the law, and also has the ability to think or to critically analyze the law and the corresponding real life situations or facts for the benefit of their client or for the sake of justice. Thus, a great lawyer actually has the ability to effectively fit the law to the facts or the facts to the law as and when necessary. Fundamentally, you could say to think like a lawyer means to think critically from a legal perspective. So to think critically about the law, about the facts that are connected to the law. That is what it generally, you could say, fundamentally means to think like a lawyer. Now, moving on to the ILAC method. The ILAC method basically, or the term ILAC is basically an abbreviation. The I stands for issue. The L stands for the law. A stands for analysis, and C for conclusion. And they are abbreviated in a chronological order. So you first start with the issue, then you move on to the law, after that the analysis, and then, of course, the conclusion. So when you're answering a problem question, you first deal with the issue, then you deal with the law, then you deal with the analysis, and of course, then you draw a conclusion. So what does it mean to deal with the issue? Well, basically, fundamentally, the first thing that you do when you face a legal problem is you identify the legal issues that are being raised by that problem. So the fundamental question that you have to ask to find what the issues are is basically, what is the legal issues, or what are the legal issues that are being raised by this particular problem? So there could be one legal issue raised by a particular problem, or there could be multiple legal issues raised by a particular problem. After you have identified the issue or issues, you move on to identifying the relevant law, which is you ask the question after you have identified the issue. Then you ask yourself, what are the relevant legal provisions or principles that may be relevant to this particular legal issue? After that, you move on to the analysis. where you ask yourself the question, how does the facts of the case or the problem interact with the relevant legal provisions or principles? So how do the facts and the law that have been raised by this problem interact with each other? Let's say, does this amount to an illegality, or does this amount to a legality? Is it permitted by law? Is it not permitted by law? Etc. So you basically apply the law to the facts of a particular problem. After you have done that, you finally come to your conclusion, where you ask yourself, what legal conclusion can be drawn from the analysis of the relevant legal provisions or principles and the facts of the present case, or the facts of the present problem. And this is how, or this is one of the efficient ways of structuring a response to a problem question. Of course, this is not the only method, but this is one of the most efficient and one of the most, let's say, logical ways of approaching a particular problem in law. Now let's deal with an example. So let's deal with an example of a problem from contract law. So the problem states that X has signed a contract with Y. The terms of the contract stated that X would pay Y 10 lakh takas if Y promises never to marry Z. As per the terms of the contract, X would pay half of the agreed sum during execution of the contract, and the other after a period of 5 years. Thereafter, the contract was duly executed and X paid Y half of the total sum at the time of the execution. Consequently, Y did not marry Z, and 5 years later, when the time arose for X to pay the latter half of the promised sum, X refused to do so. Now, Y seeks your legal advice on this matter regarding X's purported breach of the aforesaid contract. So that's the problem. It's a straightforward, let's say, contract law problem. There's an allegation of a breach of a contract. So generally, when you're faced with a problem questions, there's some preliminary questions that you should ask yourself right at the very beginning. And in case of this particular problem, for example, certain questions that you should ask yourself is, for example, is this contract between X and Y valid? If it is valid, has X breached any terms of the contract? If so, then can Y seek any remedy for X's breach of the contract? So these questions will allow you to, for example, identify the key issue here. So it's quite clear from this particular problem what the key issue is actually. And if you have some idea of contract law, you would grasp it as soon as the problem had been raised. So moving on to your answer to this problem. So since, of course, you are someone who has specific knowledge of contract law, you should have been able to easily identify the issue here. So the issue actually is whether the contract between X and Y, in this particular case, is valid or not. So that's the issue. That's the fundamental question that you need to answer in this particular problem. Then you move on to the law. What could be the relevant legal provisions that could be applicable to this particular problem. Now, the relevant law here is actually Section 26 of the Contract Act of 1872. Now, according to Section 26 of Contract Act 1872, every agreement in restraint of marriage of any person other than a minor is void. So any agreement that is in restraint of marriage is technically void, has no legal effect. So then, now that you have identified the relevant law, you now move on to identify or to analyze the facts that have been posed to you in light of this relevant legal provision. So in the present case, under the alleged contract, X promised to pay Taka 10 lakhs to Y in 2 installments in consideration for Y never marrying Z. Fundamentally, the alleged contract stipulates that if X pays the agreed sum of money to Y, Y can never marry Z. Hence, it is evident that the alleged contract is restraining Y's ability to marry Z. So that's your analysis. Then you move on to the conclusion. Now, since the contract is restraining Y's ability to marry Z, you can therefore conclude that as per Section 26 of the Contract Act of 1872, the contract between X and Y is void, since it is an agreement in restraint of marriage, and therefore it has no legal effect. Y cannot sue X for a breach of a contract that is already void. Technically void ab initio, void, which is void right from the very beginning. Now, there are certain other points that you need to bear in mind when you are dealing with a problem question. Not only dealing with a problem question, whenever you're dealing with a legal problem. Firstly, your answer should preferably be divided into paragraphs and properly structured. Of course, ILAC provides a particular structure that you could follow. Secondly, be clear and concise. Answer to the point and do not beat around the bush. Brevity is a quality of a good lawyer. Lastly, remember that you are advising a client and your audience may not be a lawyer. Hence, do not assume that the reader or the audience knows or will automatically understand what you're trying to say. So these are certain points that you should bear in mind when you are dealing with a legal problem. And that basically concludes this short video or lecture on how to answer problem questions in law through the ILAC method. Thank you very much.